Okay, this is 100, 120, and we're going to start with some phrasing. And I'll look at the outlines as well. Nevertheless, N-E-F-R-L-S, nevertheless. More or less, M-O-R-L-S, more or less. More than, M final R-N, more than. From the, F-R, final T. From the evidence, F-R-E-F-D, from the evidence. F-R-E-F-D. In fact, I have other evidence briefs I could throw in here if we wanted to. All of them end with E-F-D for evidence. Okay, so that's used in phrasing. So from the evidence, F-R-E-F-D. From time to time, F-R-I-M-T. From time to time. Your Honor, Y-O-U-R-N. Under the influence, U-F-L-S, U-F-L-S, under the influence. Under the circumstances, U-T-S, under the circumstances. Under all the circumstances, U-L-T-S. Under all the circumstances, U-L-T-S. Okay, let's do that column a couple times. Nevertheless, more or less, more than, from the evidence, from time to time, Your Honor, under the influence, under the circumstances, under all the circumstances. Is that, S-T-H, these all begin with is. Is that, S-T-H-A, is that correct? S-T-H-A-K-T, is that correct? Is that right? S-T-H-A-R-T, is that the, S-T-H-A-T. Okay, is that correct? Is that right? Is that the? Is the, initial S final T, is the. Is there, S-T-H-R, all on the initial side. S-T-H-R, is there. Is this, S-T-H, is this correct? S-T-H-K-T, is this correct? Is this right? S-T-H-R-T, is this right? Is that correct? Is that right? Is that the? Is the? Is there? Is this? Is this correct? Is this right? Okay, gonna mix them up now. Under all the circumstances, is this right? Under the circumstances, is this correct? Under the influence, is this? Your Honor, is there? From time to time, is the? From the evidence, from the? Is that the? More than? Is that right? More or less? Is that correct? Nevertheless, is that? Okay, now some sentences. Here we go. Nevertheless, I am required to be present at the bank as much as possible. His story is believable. Nevertheless, I do not believe it at this time. For the record, that's more or less the entire testimony. He's more or less to blame at this time as a result of his own neglect. Thank you for completing more than the minimum requirements. For the record, the prosecution has delivered more than enough evidence to prove guilt. From the predictions, it will be hotter this week. Have you received your instructions from the court as well as from your attorney? You shall reach your decision from the evidence in the case. For the record, Your Honor, I base my opinions in this case from the evidence alone. Your Honor, from time to time, we will request your patience. From time to time, it will be your duty to listen to the evidence as much as possible. Your Honor, the testimony is clear that the defendant was under the influence at that time. The lab results show whether or not the defendant was under the influence, Your Honor. I left as soon as I could under the circumstances. Under the circumstances, I think action should be taken as follows. Your Honor, under all the circumstances, I request you find the defendant not guilty as a result of her testimony, and under all the circumstances, I request bail be granted. Is that an exhibit that was marked for identification? Is that a matter for the jury to decide? Your name is Mary Jones. Is that correct? You were present at all times during the robbery. Is that correct? At the present time, you are unable to give me the right date. Is that right? Your true name is Betty Johnson. Is that right? As near as you can say, is that the only reason for the argument? For the record, is that the final decision, Your Honor? Is the only reason you are testifying, for example, because you were subpoenaed? All right. Is the defendant present in the courtroom at this time? Ladies and gentlemen of the jury, is there any reason you cannot remain at this time? Is there a reason you are not able to be present at any time? For instance, is this the same car you observed driving into the parking lot? As you've described the male as being as much as 225 pounds, is this correct? As a matter of fact, you don't remember the date of this incident. Is this correct? Is this right that you are no longer employed at the First Savings and Loan? You plan to testify as soon as your attorney arrives. Is this right? Okay, I'm going to put a few more up on the board, and these are phrases that end in evidence. So I'm just going to put the outline because I just think they're really that obvious. You probably have these already. It's the big, thick packet of briefs that I gave you that on the first page has green light, yellow light, red light, blue light, all of those. Okay, so you have, I think you have these. This is best evidence. Circumstantial evidence. DRED, sorry, direct, RFD. DREFD, direct evidence. Good evidence. Indirect evidence. NEFD. Physical evidence. FEFD. And lastly, relevant evidence. REFD. Okay, so what you have here is best evidence, BEFD. Sorry, this isn't showing up very well on the video. Circumstantial evidence, SEFD. Direct evidence, DREFD. Good evidence, GEFD. Indirect evidence, NEFD. Physical evidence, FEFD. Relevant evidence, REFD. Okay, we're going to read back now some of the sentences using all of these briefs, and this will give you an opportunity to recognize them in your notes. Make sure you're hitting them correctly. And I'm going to put those behind me as well. On the record. Show me your best evidence. Your Honor, that is circumstantial evidence. That contract is direct evidence. She produced good evidence. Object, indirect evidence. The purse is physical evidence. He entered relevant evidence. I find, nevertheless, that as a result of this testimony, the defendant is guilty. For instance, by his own actions, he more or less is guilty of contributory negligence. As a matter of fact, it is required that you complete more than last year at this time. From the results of the study, we can anticipate increased revenues as soon as next week. For example, you are to decide the case solely from the evidence at all times. For the record, the parties will be requesting recesses from time to time. At that time, Your Honor, the witness was under the influence of alcohol. As near as I can tell, the case should be dismissed under the circumstances. Under all the circumstances, I will excuse all jurors from further duties at this time. Is that all the evidence you wish to present at this time? As far as I can determine, you were present at that time. Is that correct? Your son's birthday is January 4, 1985. Is that right? Under all the circumstances, is that the only justification you have at this time? Is the gun marked for identification, or has it been received into evidence, Your Honor? At what time is there a recess scheduled? As a rule, is this your usual practice to go to the bank on Fridays? As the result of this action, you have been released from liability. Is that correct? You entered the store at the same time as the defendant. Is this right? Okay, let's take a look at those. And I have no idea what I read for the first ones because I just made them up, so. They make it, yeah.
Show me your best evidence.
We're just going to go back and forth here, so.
Okay.
Thank you.
Your Honor, that is circumstantial evidence. That contract is direct evidence. She produced good evidence. Object indirect evidence. The first is physical evidence. He entered real evidence?
Relevant.
Relevant.
You got the idea.
I find nevertheless that as a result of this testimony, the defendant is guilty.
For instance, by his own actions, he more or less is guilty of contributory negligence.
Contributory.
As a matter of fact, it is required that you complete more than last year at this time.
From the results of the study, we can anticipate increased revenues as soon as next week.
For example, to decide,
You are.
you are to decide the case solely from the evidence at all times.
For the record, the parties will be requesting recesses from time to time.
At that time, Your Honor, the witness was under the influence of alcohol.
As near as I can tell, the case should be dismissed under the circumstances.
Under all circumstances, I will excuse all jurors from further duties at this time.
Is that all the evidence you wish to present at this time?
As far as I can determine, you were present at that time.
There's a phrase at the end.
Oh, is that correct?
Thank you. Yeah, that's okay.
Your son's birthday is January 4, 1985. Is that right?
Under the circumstances,
Do you have an L in there?
no.
It should be under all the circumstances.
Under all the circumstances, is that the only justification you have at this time?
Is the gun marked for identification or has it been received into evidence, Your Honor?
At what time is there a recess scheduled?
As a rule, is this your usual practice to go to the bank on Fridays?
As a result of this action, you have been released from liability. Is that correct?
Of this, is this correct?
Of this, is that correct?
Yeah, is that what you had, Kate?
No, I have that.
Okay, that's probably what I said then. Good enough? Go ahead, Kate.
You entered the store at the same time as the defendant. Is this right?
Okay, very good. You should have also had, there was a lot of briefs in there also that would have been reviews, that you've learned before. So hopefully you caught those as well. Yeah, those are good, huh? Ones that make sense, that just are very easy, are usually the best ones to try and learn because they're the easiest and they make sense. Okay, I think, well, I know we did some of this the other day. I'm going to continue it. It is from this medical case. It's the doctor testifying. It was the delivery case. So I'm going to continue and read a little bit more of this. And it's really two voice, but I'm just going to be like make it be one long answer. Okay? It's just the doctor speaking. This isn't counted, so I think I'll probably get it at a decent speed. Just kind of interesting, and you get some medical in here as well. Here we go. There was an obstetric team present consisting of at least two, let's call them nurses. I'm not sure whether they were LVNs, RNs, obstetric technicians, or whatever their exact licenses were, but nursing staff from obstetrics. And then there was a lady present who was obviously, or I think obviously, the coach for the patient. I don't know what her relationship was to the patient. To this day, I don't know who was who. I was scheduled to be on duty that night. It was my afternoon off, but they had given me the call that night, and I came in. And the reason I remember 16:30 or 4:30 in answer to you earlier is I came in 30 minutes early to take over at 5 o'clock, which would normally be the time I would assume the night responsibilities. And I came in because I knew that Dr. Gill, who was covering at that point, had been up most of the night before and probably kind of tired from working all day. And so I thought I would relieve him. So I arrived at approximately 16:30 in the delivery room, give or take a minute, and got a report from Dr. Gill, as I indicated before, of the diagnosis that was being worked with at that present time. I watched them perform one vacuum extraction, which failed. The vacuum extractor is so designed that you use a certain amount of vacuum, usually somewhere around 50, 60, 65 millimeters of mercury. You pump it up. And the nice part about it in a teaching program is that it will come off before you can. You can't have residents put a lot of pressure on a vacuum extractor because it just won't hold on to the scalp. It will come off. So I watched one of these applications and the extractor came off. And in the process of doing this, why Dr. Gill asked if he might leave, if I would assume the responsibilities for watching the delivery. And in view of the fact that he had reported no complications or problems, I said, sure. I watched the application 2 more times, at which point I called a halt to the proceedings. I don't usually like to let the vacuum extractor function more than 2 or 3 times. Those are round numbers, but you just don't put them on indefinitely and keep pulling on it 100 times or 50 times or something like that. At this point, I asked them to stop putting it on, and I said, let's reevaluate the situation. So we did. And the 3 of us physicians examined the patient at this time. I thought from my examination anyway, that the patient was transverse, and that my diagnosis then became transverse presentation. Excuse me. How's the speed? Okay, let's do a little bit more. One more segment. Ready? Well, the baby is normally delivered with the back of its head facing the ceiling, okay? The mother is lying on her back, and as the baby comes out, the back of its head will be pointing to the ceiling. A baby is called anterior if this happens. If a baby comes out with its face pointing towards the ceiling, in other words, sort of upside down like, then it's called a posterior, okay? And the reason for that designation is that everything takes place on the posterior fontanelle. Here, this thing. It's through its location. If the baby is halfway in between, so that the baby's head is coming out sideways, this way, either way, so the side of the head comes out, and it's called transverse, okay? 90% or a large percentage of the babies who are delivered, particularly first babies, deliver anterior, but almost all of them will engage in a transverse position. They come down in a transverse position and then rotate so that the back of the head comes out and they rotate into an anterior. It was my opinion that this lady had not rotated. She had not rotated that head into the anterior position. So I instructed the residents to manually rotate the head. I thought she was an LOT, which means that the left occiput or the occiput was on the patient's left side. So you rotate it this way so that the head comes up. The resident did. We put the vacuum on one more time, and the vacuum came off. I called time, invited the chief resident into the hall, and told him I thought we should do a cesarean section. I said I thought we could take her over to the operating room and use trial forceps if we wanted to, but I thought that we would probably eventually end up with a cesarean. I then, at that point, went back to the nurse's station. The chief resident, Dr. Aquillano, went back into the room. Now, I don't know what happened at this point because I was not a witness to it. All I know is I went back to the nurse's station to write my note that we were going to do a section and wait for Dr. Aquillano to come out and start making the necessary phone calls to get anesthesia, etc., to set up for the section. And the next thing I know, Dr. Bowerman, the pediatrician doctor, is running out into the hall asking me to come into the operating into the delivery room stat immediately. Okay, we'll stop there. Well, we'll just have, you have to come back next week and find out. I'll leave it in my binder here and we'll find out. It's not a good result. Okay, let's do some jury. Some of our briefs will come up. Okay, here we go. Excuse me, here we go. On the record. Ladies and gentlemen of the jury, when we started this trial, we talked a lot about presumption of innocence, and each of you said yes, you would presume this man innocent. We talked about reasonable doubt, and you assured me that if you had any doubt based upon reason, that you would not hesitate in voting not guilty in this case. We also talked about credibility of witnesses, and you told me that you would consider conflicts in testimony and any other evidence. The court instructs the jury that the court is the sole judge of the law in this case, and it becomes the duty of the jury to follow the law as it is given to you by the court in these instructions. You have no right to disregard them or disregard any portion of them, but you are bound to take all of them as they are given to you by the court and apply them to this case. The indictment in this case is not to be considered as any evidence of guilt against the defendant. It is simply a formal charge necessary to place the defendant upon trial. The defendant under the law is presumed innocent of the charge in the indictment. This presumption remains with the defendant throughout the trial until you have been satisfied by the evidence in the case beyond a reasonable doubt of the guilt of the defendant. This presumption of innocence is not intended to aid anyone who is in fact guilty of a crime to escape, but is a provision of the law to help prevent an innocent person from being convicted. Before you were accepted and sworn to act as jurors in this case, you were examined by both counsel for the people and the defendant as to your competency and qualifications. As part of this examination, each of you answered all of the questions asked by both the prosecution and the defense. Your answers showed that you were competent and qualified to act as jurors, and the parties accepted you as jurors on the faith of the truth of your answers. The answers you made at that time are as binding on you now as they were then, and they will so remain until you are finally discharged from further consideration of the case. It would be improper and unlawful for any of you to disregard those answers that rendered you competent jurors. You have listened to me refer to reasonable doubt. Proof beyond a reasonable doubt is not beyond all possible or imaginary doubt, but such proof as precludes every reasonable hypothesis except that which it tends to support. It is proof to a moral certainty, such proof as satisfies the judgment and the consciences of you, the jury. The court instructs the jury that there are two kinds of evidence, direct and circumstantial. And in my opinion, there has been both kinds of evidence introduced during this trial. Direct evidence is that set of evidence by which a fact is presumed and proved directly and without inference from other facts, and is usually given by the witnesses who saw, heard, or otherwise observed some particular happening. Circumstantial evidence in criminal cases is the proof of facts and circumstances connected with or surrounding the crime charged as tend to show the guilt or innocence of the party damaged or charged. The bailiff will now escort you to the jury room. Upon reaching the jury room, you are to select one of your members to be the foreperson of the jury. Your foreperson will preside over your deliberations and such other duties as the court has described. How was that? It's pretty much all 120. Okay. I'm going to do a few minutes, a little bit faster. I'm not going to go 5 this time. And this is Norton on the record. Ladies and gentlemen of the jury, before proceeding with the court's charge, I want to join with counsel for the government and the defendant in expressing our most appreciative thanks to you for the services you have rendered here and the service that you have yet to perform in this case. I have observed that you have been most attentive to everything that the lawyers, witnesses, and the court had to say. And I have observed that you have been very punctual in attending, and I know that you will complete your service here in the best traditions of our federal courts. As you have been told, it is now. It becomes your testimony, your responsibility, and the obligation of the court to charge and instruct you in respect to the law, which you will apply to the facts as you find the facts to be from the evidence which has been introduced in this case. Evidence both spoken from the witness stand and the documentary exhibits which have been admitted into the evidence. The court proposes also to deliver instructions for your guidance in your consideration of the evidence and in your deliberations upon this case. The instructions which the court will give you insofar as they pertain to the principles of law applicable to the case, and this I said to you before you came on the jury, must be accepted by you as a binding control and guide in your consideration of the evidence. and in your deliberations. You will recall when you were examined and later accepted as jurors that the lawyers for both the government and the defendant agreed that you might serve as jurors on the basis of the answers which you made when you were questioned as to your qualifications. The answers you then made to those questions in regard to your competency, qualifications, and your fairness are as binding upon you now as they were then and should so remain until you are finally discharged from further responsibility and consideration of the case. It would be improper and unlawful for any of you to discuss the answers that rendered you competent to serve as jurors in this case.